Ladies and gentlemen, the Senzo Meyiwa trial just took yet another shocking twist. Advocate Baloyi, in his relentless cross-examination of Muzi Sibiya, dragged in the name of a traditional healer, a Sangoma, Lionel Zwane. He claimed Sibiya confessed to visiting this healer with Marco and Makhimba, the Buthelezi brothers. But here's the kicker: Sibiya flat out denied ever making such a statement, insisting it was not his words, but those of Brigadier Gininda. Tonight we unpack exactly what happened, what it means, and what legal experts like Mpumelelo Zikalala have said about the role of traditional healers in South African courts. In the courtroom, Advocate Baloyi leaned into the controversial ground, bringing up the name of Lionel Zwane, a Sangoma. According to the alleged confession, Sibiya, Marco, and Makhimba went to this traditional healer, but when pressed, Sibiya was firm. That is not my statement. That is Gininda's fabrication. This statement deepens the battle of credibility in this trial. Who do we believe? The police investigators and their paperwork, or the accused, who claims his words were twisted to fit a narrative?
We drove to the traditional healer, Mkhulu, as we used to call him, and he is from Swaziland. This is the traditional healer we used to go to before we commit any crime. He is from Swaziland. Paragraph 5. The Inyanga stays at Katlehong at Palm Ridge, and we entered there, 3 of us. Marco is the one who explained to traditional healer, in parenthesis, Mkhulu, that we want to check if we are going to succeed in doing this job. He further mentioned to Mkhulu that we are going to kill Senzo Meyiwa, and we were bought or hired by Kelly Kumalo, who was a girlfriend to Senzo Meyiwa.
Together with Mboto.
Now, Mr. Sibiya, we know that a traditional healer by the name of Mr. Lionel Robert Zwane testified in these proceedings, and we find his evidence in the proceedings of the 4th of September 2023 from page 20, page 37. Yes, we will revert to his evidence later. Paragraph 6. Paragraph 6. Marco told us that Kelly wants money from Senzo, but he never told Mkhulu that. Mkhulu, in parenthesis, traditional healer, checked for us and said we are going to succeed to kill the said person, and he also gave us protection in brackets, protection in parenthesis, medicine, and belts to put on our arms or at our waist, and which was going to make us to succeed in killing him and to protect us from any danger. We paid Mkhulu 50 rand for checking our job. Paragraph 7. When we finished the job, we decided that we must pay him, in brackets, Mkhulu, 5,000 rand, and we left to the hostel, and they left me there to their place of residence. I sat at my place and never spoke till Saturday, in bracket Sabata, where I received the call from Marco, where he told me that we are going afternoon to the work which we're planning to do.
Angazi lutho ngalento le umuntu ongazi ngayo uGininda noMbotho.
Paragraph 8. They never told me the time, but they arrived at about 1800 hours and they took me by the very same polo.
Angazi lutho ngayo yonke lento le ngaba uGininda noMbotho abazi ngayo.
I was sitting at the back seat. Makhimba was driving. The vehicle drove to the address Foslores and the vehicle parked by the corner as Makhimba was driving. While we were driving to the place, Marco received the call and I heard Marco answering the phone and said, "We are on the way, coming," in brackets, Sisondleleni.
Namanje ngisasha angazi lutho ngayo yonke lento le. uGininda noMbotho abantu abangazi ngayo yonke lento.
But Lieutenant Colonel Mboto was not part of the investigation. How would he have known about all this?
uMbotho uyafonela uGininda bahlangana khona mabebuya sebeza kimi lapha sesekhodi yathi bafika sebefika kwethu.
Paragraph 9. After dropping the call, he told us that Kelly is calling and want to know if we are coming. Then we alighted at the corner and we walked on foot to the house, and the driver was with Marco and he asked who was going to enter the house. We discussed that we will make as if we are committing robbery and the firearm was the one and it was at Marco's possession.
Angazi lutho ngayo yonke lento le umuntu ongazi uGininda noMbotho. uGininda washo la eKatolo uthi uyafonela uMbotho.
Paragraph 10. Marco asked who was going to get in, and I told them, "No, me, I'm going to stand outside and watch if there is somebody who came in and disturb us. I must quickly report."
Namanje ngisasha angazi lutho ngayo yonke lento le ebhalwe la uGininda noMbotho abantu abangaba nolwazi lwayo.
Marco and Makhimba got into the house, and Marco was the only one who was in possession of the firearm.
Angazi lutho ngayo yonke lento le ngoba ngisho ukuthi ngaba uGininda noMbotho abantu abanolwazi lwalento.
Paragraph 11. They entered and closed the door and demanded cell phones. According to them, they said they found 3 people in the house. That was Meyiwa and 2 girls in the dining room. One of those 2 girls was Kelly. They said Meyiwa refused with cell phone and he stood and grabbed each other with Marco.
To better understand this, we must ask, how do courts treat claims involving traditional healers? Legal analyst Mpumelelo Zikalala has often weighed in on this issue. He explains that while traditional healing and beliefs form part of South African culture, courts require hard evidence, documents, witnesses, and facts, not spiritual consultations or rituals. A Sangoma's involvement may be part of an accused's story, but it cannot on its own establish guilt or innocence. Zikalala points out that unless what happened at a traditional healer's place is supported by concrete proof, it carries little legal weight. Courts cannot convict on belief, they convict on evidence. Zikalala coming in, stay tuned.
Good afternoon to you and also to your viewers. Yes, they are, but you must remember that the only privilege which is ultimate in this case would be that of a client and a legal practitioner. So when it comes to medical doctors, a medical doctor can be subpoenaed to come and give evidence in a court of law. So once they've been caught by the court or subpoenaed by the court to come and be witnesses, then the client or the patient in medical practitioner privilege goes out the window and they are forced to come and spill the beans in terms of what was happening within the particular stage. But in this one, I did not think that it's really assisted the case, the state in this, because he didn't go into details as to what they came to about. So there was no indirect confession that was made stating that this is what we have done, someone has died. He simply says someone will email. There could be various versions of saying someone has been injured. So it did not bolster the case of the state in any case, but I think it added to the drawing up of the bigger picture and what the state would want to do, especially drawing a very good impression from the side of the judge in terms of saying, look at how planned this whole process was. They even thought about going to the traditional healer even after doing the bad deed, because they knew that there were going to be repercussions if they're going to be there. But in terms of what the normal manner of doing things would have been done, a traditional healer would not be called. But I think in this case, the state is saying we're going to go all out because we need to come back with the conviction in this case.
He was not able to identify any one of those men, merely just mentioning a surname, and that could belong to anybody in South Africa.
Definitely. And you must also look into how many people would go to a traditional healer. When did they go? Plus minus more than a decade ago. Or even further. Then the question is, can you be able to remember someone that you consulted with that you do not see on a daily basis? You've only spent plus minus not more than an hour with them. How accurate are you that this is the individual that they are referring to? So if they are not going to provide those intimate details, if I was the prosecution in this case, I wouldn't have even called them, because they are not going to assist this matter in going anywhere. The only evidence which is going to be crucial is place those particular individuals at the scene of the crime, place them within the planning stages of this particular crime, so that you're able to fit in, or you point the doctrine of common purpose to everyone that is there, and then speak about the motivation which they would have, or the motivating factor that would have fueled them to engage in this particular act. If you are able to do that and find credible evidence, and your expert witnesses are able to point to that, then you're going to come with the conviction. In this case, the traditional healer did not assist in any manner.
From the work that you do, is it unusual? Do you find traditional healers taking to the stand in South Africa and giving evidence?
No, not at all. Or even though they're not barred from doing so, they can go to court, and the state has the ability to call them, but they don't usually add any additional info to whatever which evidence which is required. So the court is very clear. It says, look at the elements of the crime. This is what you need to come. We need to come to. This is what needs to be proved. If you're not able to prove all those things, then it doesn't matter. When it comes to motive, maybe you can go to another manner, but at the end of the day, they don't really add any value to the evidence which is required by the court.
So when Sibiya says, "That's not me, that's Gininda's statement," he is not just denying the Sangoma angle. He is accusing police investigators of fabricating confessions. If that's true, it raises the stakes dramatically. Were statements doctored to implicate the accused, or is Sibiya trying to escape a damning admission? This is not just about a healer. It's about whether the state's evidence is authentic or tainted. The mention of Lionel Zwane has sparked debates outside court, too. Many South Africans ask, why is a Sangoma even part of this murder case? Others say this shows just how deep and desperate the investigators were to connect cultural practices to crime. But at the end of the day, the judge has one mandate: filter belief from fact, culture from law. So here's the big question. Will the court dismiss this Sangoma story as irrelevant folklore, or will it be treated as a serious piece of the puzzle in Senzo Meyiwa's murder trial? And just as importantly, if Sibiya is telling the truth that Gininda authored these words, how much of the so-called confessions can really be trusted? What do you think? Should traditional healers have any role in criminal trials, or should the court stick strictly to hard evidence? Drop your thoughts below, because this debate touches culture, law, and justice itself. Don't forget to like, share, and subscribe, because this trial is only getting more explosive. I'm Skybridge, and thank you very much for watching. I'll catch you on my next upload. Bye!